This morning on the AGI Issues program, a pleasure to bring on the program on the road this morning, Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
Well, I appreciate you being on to the program as well. And
yeah.
Let's get started with a couple of topics that you were have discussed and have written about, and one is the USDA Supplemental Disaster Relief Program as well. Now, it's going to start to have some effects on the adjusted gross income because the adjusted AGI means adjusted gross income, but it's being judged, the SDRP, against AGI in a different way, and that's starting to cause some issues.
Yeah, we've got confusion on this because we've got inconsistent application by FSA on this. And let me just give a little bit of background on this because the source of the confusion comes when we look at the ECAP program, the Emergency Commodity Assistance Program. That's where producers got an extra payment limit of more than 75% of their gross income was from farming. But that computation was only for ECAP. And under ECAP, AGI meant average gross income. But for SDRP, AGI means adjusted gross income. And that's the rub. They're not using the same definition. And we've got one definition for tax purposes, two separate definitions for this. So under SDRP, a producer is going to have net income from farming to qualify for an extra payment. And that's an issue because currently equipment gains and income from custom farming is not to be considered as farm income unless a producer's normal farm AGI is at least 2/3 of total AGI. You got it? See how confusing that is? Now, under the One Big Beautiful Bill Act, starting with the 2025 crop year, but that would be next year, so that's a payment that starts in October of 26. They fixed this. The definition of farm income will automatically include equipment gains along with income from agritourism and activities from direct marketing of farm commodities to consumers. I was a part of a group that was pounding on FSA for a number of years to get that corrected because there was a change made by the Tax Cuts and Jobs Act that said if you trade equipment, that's not going to be treated as a like-kind exchange. We're not going to route that through Schedule F. That's going to go through 4797. Well, it wipes out self-employment tax when you do that. But the other problem is FSA doesn't see that then and doesn't count that as farm income. The problem is, Greg, you could have the bulk of a farmer's income in any particular year coming from equipment trades. And now FSA wasn't seeing that. Well, finally, since FSA and the national office wouldn't budge on that, Congress changed it. But that's only for the next crop year. So we now, for the 25 crop year, for payments that start October 126. So we still have this problem and this distinction in the definition. Now, some people may approach FSA and they'll tell you, oh, no, the definition is the same. It's not. It's not the same. I also had contact last week from somebody that said, well, on SDRP, my spouse will qualify for it. Remember, that's for prior crop years. But my spouse has died, and we didn't have to open an estate. And so I went to the FSA, and they said, well, you're not entitled to payments because an estate was not open. That's incorrect. There's a form for that FSA has, and apparently the local office didn't know that. So I'm getting a lot of these SDRP questions. There's a lot of misinformation that's out there on it, and the confusion over AGI is a big one.
Well, then I'll ask. Well, I don't know if it's a simple answer to this question or simple question, but why the two definitions on this? And I would assume it would be something that they should have seen or should have recognized when they were putting this together.
That's a real good question. I don't have an answer for that. I don't know how this happens this way. I think the congressional intent, I can tell you this, is that we have one definition. We follow the tax code. That's not how this came out in terms of the regulatory body here. They're using two different definitions. And even, as I mentioned, inside the agency itself, you got people that don't understand that two definitions are being used. And it's requiring a lot of discussions to explain what the problem is. But ECAP, let me go back to ECAP, because ECAP, your AGI calculation, started with a producer's total income before most adjustments and deductions. And so it included income from all sources, farming and off-farm jobs and investments, any other revenue you had. And so we were familiar with that calculation. And of course, why this is important is because we have a couple of caps. We have a $900,000 cap for being eligible to participate in federal farm programs. And then you have the exception there. Well, if 75% or more of your AGI comes from farm sources, then the cap comes off, and you can get a bump up on your payment limit per person. Well, okay, so we had that computation for ECAP. Well, AGI for SDRP is the figure from line 11 on the 1040, and that's a different calculation. That's your total income from all sources less above-the-line deductions and adjustments. And so that's going to include deductions for things like IRA contributions and student loan interest, a portion of self-employment tax. But the biggest issue for complex farm businesses is that AGI figure can be significantly reduced for non-cash expenses such as depreciation, as well as your pass-through losses from other businesses. So this really limits what your SDRP payment would be, perhaps for a farmer that operates in a partnership or an S corporation, because you're going to subtract out your depreciation on equipment, and now bonus depreciation this year is back to 100% for assets placed in service on or after January 20th of this year. And expense method depreciation is going to ramp up, but you've got the bonus that's been there. It was 40%. Otherwise, it was 40% this year. And you've got 179. So farmers can take a lot of depreciation on an asset. So that could be a big deduction that drops out. And so I've got an example in my article where I start out with gross farm income from all sources, $1.5 million. Take out depreciation on equipment of $500,000, take out passive losses from a feedlot, say an S corporation, another $300,000, so that's $800,000 you're reducing that by. And then let's say we have pass-through losses from a grain partnership that the farmer's in, it's another $100,000, other above-the-line deductions, $50,000. So I'm pulling off $950,000, so my final AGI is $550,000. Instead of $1.5 million. So that much smaller number, due to the accounting rules, is there, even though he had a high gross income. So if the SDRP has a payment limit based on a much lower AGI threshold, that farmer's substantial losses will not fully be reflected because his AGI is still too high to qualify for full benefits that he'd otherwise be entitled to. So the AGI, what I'm saying is this, the AGI figure on his tax return doesn't tell the whole story of his financial losses, which SDRP is designed to cover. That's the problem in a nutshell. Because,
you have a lower AGI, people would think that's a good thing, but that becomes a problem in this scenario.
That's exactly right. And the point is that AGI is a highly manipulated number that's designed to reduce the tax bill. And so in my example, a total of $950,000 in legitimate deductions for that farmer were subtracted from gross income. And that's a common and legal tax strategy for farm businesses and other businesses, particularly those that are more complex in their setup for various reasons, partnerships and S corporations. So when USDA uses that lower AGI figure to determine a payment limit for disaster relief, there you've got a problem. So a farmer has got $1.5 million operation. They may have suffered hundreds of thousands of dollars in crop and livestock losses, but they're judged by a final AGI of only $550,000. So if your SDRP has a payment cap, say $900,000, that $1.5 million business is automatically penalized because their AGI is too high to get the full benefits, and that's the problem that I'm addressing.
Well, and it shows a lot of it, the lack of transparency on how USDA interprets and applies AGI data. Now, are there potential, if Congress is able to do this, and, God only knows in this case, what would be some of the issues or be able to fix the issues that you're seeing here with the situation you laid out?
Well, remember, for next year, Congress has already fixed the issue in the One Big Beautiful Bill Act, primarily because they're going to pull in gains from equipment sales into the computation. But in the short term and going forward, they do need to do a few things. And again, I mentioned these in my article. I think they need to develop new procedures that more accurately account for the unique financial characteristics of farming operations, and maybe something that's more tailored rather than the standard AGI, and maybe one that isolates farm-specific income and expenses, because farm tax is unique compared to other taxpayers, and you've got to account for that uniqueness. That's why I travel the country teaching farm tax, because it is so unique. Also, I think the SDRP's criteria should be updated to consider factors like depreciation schedules and pass-through losses and other farm-specific accounting variables that will give you a realistic assessment of the producer's financial health following a disaster, and then put out clear guidance that's more accessible on how eligibility is determined. And that would, I think, give producers and their financial advisors the ability to better understand the program's requirements and navigate the application process.
You know, another part of this as well is if you're filing a joint return, but let's just say the spouse has income from an off-farm job, and I know several people or families that are like that. You know several families that are like that. Mm-hmm. That's another issue too.
Yeah, I've had numerous questions come in from CPAs on this one, but for purposes of the SDRP, the AGI is based on the figure from a producer's tax return. So when that producer files a joint return with their spouse, if the spouse has income from an off-farm job, that's in the AGI calculation. The IRS combines all income and deductions for both individuals into a single unified return. And so the AGI figure on the return, which is line 11, is then combined with the AGI for both spouses. Now, you could have a joint return then where your combined AGI that's reported to USDA for SDR purposes would be inflated. It would be too high. And so the issue here is that the spouse's off-farm income inflates that AGI, and it makes it harder for the family to meet the program's eligibility requirements or get the full amount of disaster relief they would otherwise be entitled to. And otherwise, you're penalized by a spouse that has an off-farm job because it's going into the calculation. They're not differentiating between farm income and non-farm income. So what do you do about that? Well, you need to know that that's the issue with respect to this program. Maybe you file a separate return, but if you file a separate return, then that creates other potential problems that are out there with respect to other provisions in the tax code where it doesn't make sense to be filing a separate return. So that's another issue that needs to be dealt with. Some of the other programs that USDA has allows you to back out off-farm income, and you do an allocation, and then you have your CPA or your tax advisor, your accountant, attach a form with the return and explain the allocation and the amount of the off-farm income. That's not happening with SDRP right now.
And really, with this, if nothing happens this year, as far as SDRP is concerned, in the end, it's going to it sounds like it's going to fail many of the producers that it was designed to help.
Well, we'll see what happens in stage 2. We're supposed to get those rules in mid-September, and they've got a chance here to see what's happened and modify the rules in stage 2 and pick up what was missed in stage 1. So I'm not sure I would go that far, Greg, simply because stage 2 is coming, and they've got a chance to kind of catch themselves here and make up for some lost ground.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, of course, talking about Roundup Ready soybeans, the original Roundup Ready soybeans that was developed at the time by Monsanto, which Monsanto is now a part of Bayer, have come off patent, making, pretty much a significant shift in the agricultural landscape. But it's one, too, of the reselling of off-patent seeds that you had another topic of discussion.
Yeah, the bottom line is that the expiration of the Roundup Ready patent does represent a rare opportunity in agriculture. It gives farmers access to a widely used biotech trait without the high cost of intellectual property. Now, while the original, the Roundup Ready 1, or RR1 is how they're referred to, while they may not match the performance of the newer seed technologies, that its availability gives farmers more flexibility and power in choosing how they grow their crops. But I had a question come in recently about, well, I want to form a buyer co-op, in essence, a pool, to buy these seeds on volume and then sell them to farmers at less than market price, but maybe at or a little bit more than what they purchased them at. And my response to that turned into an article, and that is, you got to be careful with this. Even with the patent having expired, that doesn't mean you can freely resell or distribute the seed. That's because those traits may still be covered under other intellectual property protections. There may be a utility patent on other genetic traits. There may be stacked traits, is what I'm saying. So you might have some expiration. You might have some that's not that they're still covered by a patent. There also may be contractual restrictions on the seed, and there might be trademarks or brand licensing agreements. So in general, to legally sell the seed in the U.S., also you may have to be a registered seed dealer, and that's the case in many states. And, of course, the seed that you sell is going to have to be labeled with origin and purity and germination percentage and weed seed percentage and all that stuff. And you're going to have to test for germination. So my bottom line on this, I know we're running short on time, is, yeah, you can do it, but you still have to make sure you check to see if there aren't any other types of intellectual property rights that still remain, because you don't want to violate those. And I can imagine that the companies that had the original patents probably you may get a little bit of blowback from them and get questioned, and I'm not sure you want to go down that road. So you still have to meet all federal and state laws, and there may be Plant Variety Protection Act a certificate that's out there, and you got to get permission of the holder of the Plant Variety Protection Certificate. So there's a whole bunch of things you have to check before you can sell these things, and that's what I go through in my article, and that's the point that I wanted to get across today.
Yeah, and there are some, in this scenario, there are some alternative approaches that you could look at, too.
Yeah, sure. There are places like Kansas State that has seed that's in the public domain. You could use that. You could do a grain buying pool, and that might be an option, like a CSA-style grain buying network, and avoid all the seed-related legal complexity. So that's a community-supported agriculture network. And then breeding, if you've got time and you've got space. Another option is to select an open pollinated line over a few years and then breed it for traits such as early maturity and cold tolerance or drought resistance. And then once you develop your line, then you sell the seed as a new locally adapted variety. Get a PVPA certificate for that, or form a co-op, form a seed co-op that legally licenses genetics, handles germination testing and cleaning and packaging, and complies with state law. So you do have some options.
All right. Roger, we're out of time, but as always, if people want to learn more about what we discussed this morning and other topics of discussion, they can go to your blog or go to your Substack?
That's right. They can go to my blog, and that's washburnlaw.edu/Walter, WALTR, and then my Substack, where I've got a lot of other technical things, plus videos and so forth. And just put one up on property rights yesterday. That's McEowen Ag Law and Tax. That's all run together, .substack.com.
All right. Roger, as always, we appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program this morning here on 580 WIBW.